India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here's the headlines. LK Advani, Murli Manohar Joshi and 30 others acquitted by special CBI court in Babri demolition case. Accused leaders tried to stop Babri demolition, says court. Supreme Court rejects plea to defer UPSC preliminaries, exam scheduled to be held on October 4th. Supreme Court issues notice to Maharashtra Legislative Assembly in Arnav Goswami plea, asks is breach of privilege akin to contempt. In Hathras gang rape case, Delhi Commissioner for Women Rights to CJI Bobde asked to take cognizance of the crime, says fundamental rights of victim violated by UP government.
India Legal presents Courts Roundup.
The CBI court has acquitted all 32 accused in the Babri Masjid demolition case. This ends the long-pending dispute related with the December 6, 1992 incident. In its verdict, the judge said the demolition wasn't pre-planned, citing that there is no conclusive proof of all 32 were acquitted by the court. Special CBI Judge Surendra Kumar Yadav has delivered his verdict in the Babri Masjid demolition case on Wednesday, 28 years after the 16th century structure was razed by a mob in Uttar Pradesh Ayodhya town. In a hearing that lasted just about 10 minutes, the judge ruled the CBI had not been able to establish charges against the accused. Special CBI Judge Surendra Kumar Yadav did not admit the videos produced by the Central Bureau of Investigation, holding that the recording has been tampered with. Defense lawyer Manish Tripathi said the judge also did not admit the photographs submitted by the CBI since it could not produce the original negatives. The judge also agreed with the defense that the CBI did not follow provisions of the Evidence Act. Defense lawyer Manish Tripathi told reporters that the court ordered acquittal on grounds that the evidence against them was insufficient. Tripathi said, giving the details of the court verdict, the court said the Rashtriya Swayamsevak Sangh and the Vishwa Hindu Parishad did not have a role in the demolition. It was carried out by mischievous elements.
सभी अक्यूज को न्यायालय ने आज बाइज्जत बरी किया है और कोर्ट की ओपिनियन जो ओपन कोर्ट में जब जजमेंट न्यायालय दे रहा था तो उनकी ओपिनियन ये आई कि जो भी वहां लाखों कार सेवक उपस्थित हुए थे वो किसी केवल हाई कोर्ट सुप्रीम कोर्ट के निर्णय के अनुसार वहां पे उनको कार सेवा करनी थी। तो ये कोई पूर्व प्रायोजित नहीं था, एक समय वो घटना हो गई और बाकी जितने भी ये बाकी लोग वहां पे उपस्थित नेता थे, भाजपा के नेता थे, वो लोगों ने प्रयास किया था उस घटना को रोकने के लिए। दूसरी बात, सीबीआई ने जो कैसेट्स दाखिल की थी वो भी कोर्ट ने माना कि वो टेम्पर्ड थी, सील बंद नहीं थी।
विश्व हिंदू परिषद का या संघ परिवार का कोई योगदान नहीं था। ये ऐसे कुछ अराजक तत्वों ने ढांचा गिराया था और इन लोगों ने लगातार प्रयास किए रोकने को। 12 बजे तक स्थिति सब नॉर्मल थी, फिर पीछे से कार सेवकों ने, कुछ लोगों ने, अराजक तत्वों ने पत्थरबाजी वगैरह की है और उसमें कहीं इन लोगों का इन्वॉल्वमेंट प्रत्यक्ष या अप्रत्यक्ष नहीं था।
The key accused included former Deputy Prime Minister LK Advani, former Union Minister MM Joshi and Uma Bharti, and former Uttar Pradesh Chief Minister Kalyan Singh. Most of the senior leaders among the 32 accused, such as LK Advani and Murli Manohar Joshi, were not present in the Lucknow court but marked their presence via video conference.
और वो निर्णय इस बात को सिद्ध करता है कि 6 दिसंबर को अयोध्या में हुई घटनाओं के लिए कोई षड्यंत्र या किसी प्रकार का ऐसा आयोजन नहीं था, वो अचानक हुआ है।
स्पेशल कोर्ट का आज का जो निर्णय हुआ है वह अत्यंत महत्वपूर्ण है और हम सब के लिए बहुत खुशी का प्रसंग है।
The 32 accused face charges under several sections of the IPC, including criminal conspiracy, rioting, promoting enmity between different groups, and unlawful assembly. During the trial, the Central Bureau of Investigation produced 351 witnesses and 600 documents as evidence before the CBI court. The court had initially framed charges against 49 accused. 17 accused died since then. Bureau Report. The Supreme Court has refused to pass direction for postponement of the Union Public Service Commission preliminary exam scheduled to be held on October 4th. The court, however, has asked UPSC to consider granting certain relaxation for candidates appearing in their last attempt. The court dismissed the petition which sought the postponement of the exam, citing various issues arising due to COVID-19 pandemic. Supreme Court said every year there are some issues like environmental issues and others, and this is not a case for students appearing. These are to be public servants and they should act like that. Come out of your shell and comfort zone. The bench of Justice A.M. Khanwalkar, B.R. Gavya and Krishna Murari said that UPSC may consider granting an extra attempt to those candidates for whom the October exam is the last attempt if they are unable to write this exam on the account of COVID-19. However, the same is to be done without extending the upper age limit, the court clarified. The court has also directed UPSC to issue direction to various states to enable candidates to be lodged at hotels near the exam centers by furnishing their admit cards. This direction comes from the court, keeping in view that the SOPs and guidelines put in place differ from state to state. Candidates infected with novel coronavirus may not be allowed inside the exam centers, the court observed, without passing any specific order in this regard. The Supreme Court has issued notice to Maharashtra Legislative Assembly in the plea filed by journalist Arnav Goswami challenging the show cause notice served upon him for alleged breach of privilege. The bench of Chief Justice of India S.A. Bobde and Justices A.S. Bopana and V. Ramasubramanian observed that it was not yet clear on whether the privilege committee of the Maharashtra Assembly has pondered over the show cause notice and that Goswami should present himself before the committee to clarify. Senior advocate Harish Salve, appearing for Goswami, maintained that they were challenging the jurisdiction of the assembly itself, as the power to summon anyone for breach of privilege did not extend beyond the assembly. Salve further argued that breach of privilege can only be invoked if the working of the House or a member is disrupted. The court also asked Salve to show how a breach of privilege is different from contempt and to present case laws to substantiate the proposition. If you criticize a man, then won't it intimidate his performance, asked CJI Bobde. Salve countered that Goswami may blame the chief minister or defame him. However, for this, a defamation case has to be filed and not a breach of privilege motion. The CJI, however, clarified that no motion has been passed and that Goswami has only been asked for a reply. The matter will be taken up next week. The Supreme Court has deferred to October 8 the hearing on the challenge by Vijay Mallya United Beverage against the Karnataka High Court upholding the order of its winding up. The bench of Justices U. Lalit, Vinit Saran and Ravindra Bhatt shall also examine whether attached assets of fugitive Mallya United Beverages Holding Limited can be used to settle the debts owned by the banks, including the State Bank of India. The response of the banks has been received, and the basic question is that since the company's assets exceed the total debts, the outstanding liability, this is not a case where the company is to be directed to be wound up. Further, the assets were attached by the ED so much so that none is available to the banks, and hence the operation cannot be said to be bona fide, said senior advocate C.S. Vidyanand for the petitioner. The PMLA operates on the basis that there are proceeds of crime in your hands, the bench sought to know. The PMLA investigation revealed that out of the total amount sanctioned by the IDBI, the major amount was remitted outside of India. It was said to be employed towards payments of aircrafts and spare parts. There was huge variation in these payments, particularly in this turn. Senior advocate Mukul Rohatgi, appearing for the SBI, argued the bench then inquired from the counsel as to how many appeals are there in all and what is the status of those appeals. Upon being informed, the bench decided to list together all appeals arising out of the same winding proceedings and take them up on October 8th. The Delhi Commission for Women has written to Chief Justice of India S.A. Bobde and other judges of the Supreme Court requesting them to take cognizance of gruesome gang rape and murder of a Dalit girl in Uttar Pradesh Hathras district. DCW Chief Swati Maliwal has requested the Supreme Court to call for a High Court monitor investigation into the case to ensure strictest and swiftest possible punishment to the accused. The victim, a 19-year-old girl, was gang raped in Hathras on September 14. She succumbed to her injuries at Delhi's Safdarjung Hospital yesterday. The latest states, even in death, the UP government was not moved by the pleas and tears of the victims and gravest of grave violation of human rights of the victim. Her family was locked up in their room and her body was forcibly taken in the field at 2 a.m. in the morning and cremated by the police officials. No family members was allowed to cremate the body in death. The family could not be with their daughters. The incident was allegedly played down by the police and the local administration as a dispute between villages to cover it up, the letter points out. In this light, the DCW has asked for the immediate suspension and punitive action against the police and administrative officials who facilitated this cover-up. The later states, DCW goes on to state that the incident exposed the absolute apathy and disregard of the system towards women. Despite the victim in this case being left in the field with several injuries, the police failed to register an FIR for 5 days. Later notes, we are now joined by Advocate Divyanshi. Divyanshi, update us on today's court proceedings.
Chairperson of Delhi Commission for Women has written a letter to the Chief Justice of India to take cognizance over Hathras case. She has contended that the fundamental rights and human rights of victims are being violated. She urges that CBI should take action on it and direct to the High Court concerned to monitor the investigation and trial and make sure that it will ensure it in the swiftest way possible. She also urges to take strict action against all defaulters, including police officers.
Well, thank you, Divyanshi, for the update. Delhi High Court has issued notice in a bail plea moved by Religare Finvest ex-promoter Shivendra Mohan Singh. The single bench of Justice Anu Malhotra has issued notice to the Delhi government and will take up the matter on 12th of October. Shivendra Mohan Singh is accused of money laundering as per the offences laid down in Section 3 and 4 of the Prevention of Money Laundering Act. He, along with his brother Malvinder Singh and Sunil Godwani, are accused of committing financial fraud running into 3,000 crore rupees, which is dated to the period of their ownership of Religare Finvest. Earlier, the Delhi High Court had granted bail to Savinder Singh in the case which is being investigated by the Enforcement Directorate. However, Singh could not be released from jail as an appeal against that order is now pending before the Supreme Court. Both Shilvinder and his elder brother Malvinder Mohan Singh were arrested by the Economic Offence Wing of the Delhi Police last December in a case related to alleged misappropriation of funds at Railgear Finvest Limited, which was an arm of Railgear Enterprises. The EOW alleged that the Singh brothers had connived with the employees of Lakshmi Vilas Bank and misappropriation to FDs of 400 crore rupees and 350 crore rupees made with the Lakshmi Vilas Bank by the compliant company. The EOW registered a FIR in March after it received a complaint from RLF against Shivander Godwani and others, alleging that loans were taken by them while managing the firm, but the money was invested in other companies. The Delhi High Court refused to entertain a public interest litigation seeking criminal action against Twitter for promoting Khalistan movement. Without commenting on the merits of the issue raised in the petition, a division bench of Justice Hema Kohli and Subramoniam Prasad refused to interfere on the ground that the petitioner Sangeeta Sharma had not made a representation before the central government. The Delhi High Court has allowed the petitioner to move a representation before the concerned authorities in a plea seeking regulation of anti-India content on social media. The division bench said that court can't sit in the judicial review under Article 226 of the Constitution when no representation was first made before the concerned authority. While Nigam informed that Member of Parliament Anand Kumar Hegre had raised the issue, court stated that no such issue had been flagged by the petitioner before the central government. The court said, "We don't propose to entertain this petition without the petitioner first making a representation." He added that the process of formulation rules and regulations to govern social media was on. In view of the above discussion, the petitioner sought the central court's permission to withdraw the PIL with liberty to make a representation to the central government. The request was allowed by court and the PIL was withdrawn. According to the petitioner, Twitter Communication India was responsible for spreading the Khalistani movement and anti-national agenda to public at large. The Delhi government has told the Delhi High Court that some media portals have peddled fake reports on seroprevalence of COVID-19 in Delhi. The said statement was made before the division bench of Justice Hema Kohli and Justice Subramoniam Prasad after the court pulled up the Delhi government for leaking the said serosurveillance reports to the media before producing the same before the court. Appearing for the Delhi government, Mr. Satyakam informed the court that the actual seroprevalence in Delhi is 25%, while the media report showed it to be 33%. At this point, the court asked the government as to why it did not deny the veracity of such reports in public domain when it knew that they were fake. No response was received by the court on this query. The court continued to pull up the Delhi government for not carrying out RT-PCR test as per the full capacity. The court asked the government to explain as to why, despite multiple orders, the government is not fully utilizing the RT-PCR capacity, which is globally known as the golden test. The Delhi High Court has imposed cost of 50,000 rupees on a petitioner seeking financial assistance of 70,000 crore rupees and human resource from the government authorities for the implementation of his project on maintaining a clean and healthy environment. The order was passed by a division bench of Chief Justice D.N. Patel and Justice Pratik Jalan while hearing a public interest litigation by one Trilok Goyal petitioner, while referring to the problem of waterlogging, air pollution, road accidents and others. The petitioner informed that court that he had a project which, if implemented, would give a clean and healthy environment. Stating that the resources required for his proposed project were not within his capacity, he urged the court to pass an order directing that a team of about 30 persons from various government departments be placed at his disposal. Petitioner submitted that the required budget will be approximately the same as the budget allocated under the Mahatma Gandhi National Rural Employment Guarantee Act 2005, that is approximately 70,000 crore rupees, which may be provided by the respondent authorities. In view of the submission made by the petitioner, the court opined that it was not a public interest litigation but a perverse litigation, since it is full of absurdity. The PIL was thus dismissed with cost of 50,000 rupees on the petitioner. The Gujarat High Court has accepted an application of farmer leader Akali Gogoi, in which Gogoi has challenged the dismissal of bail by the NIA Special Court in a case registered in connection with the alleged role in violent demonstration against the amendment citizenship law in Assam. The division bench of Justice Kalyan Rai Surana and Ajit Borthakur observed that the learned AAP seeks at least 4 weeks' time to respond. However, as this is essentially a matter relating to bail and personal liberty of the applicant, we are inclined to grant only 2 weeks' time. Gogoi bail appeal was rejected by NIA Special Court on August 7th. Gogoi was arrested on December 12th last year from Jorhat in view of deteriorating law and order situation in the state. He was handed over to the NIA for his alleged role in the violent demonstration and his possible involvement with Maoist elements. The division bench has directed the National Investigation Agency to present the record of the case on October 13. The Lucknow bench of the Allahabad High Court recently came down heavily on a petitioner who filed a plea against the airing of web series Virgin Bhaskar Season 2 streaming on OTT platforms, finding that his plea was tainted with the oblique motive of publicity. The court took particular exception to the dissemination of the petition over the internet before it was filed in the court. Finding that petitioner was not deprived and that he was not seeking the enforcement of basic human rights, the court recorded its finding that the litigation was prompted by a desire for publicity. The petition filed by Kishan Kanhaiya Pal in person sought a stay on the broadcast of the web series Virgin Bhaskar Season 2. The petitioner alleged that certain scenes in the series was defamatory because the name of a deity, Maharani Ahilyabai Holkar, is used as the name of the hostel, Ahilyabai Girls Hostel. The Allahabad High Court has expressed displeasure at the fact that not only the police authorities had failed to effectively enforce social distancing and wearing of masks, but they themselves are seen roaming about without masks. Quite often, it has been found that even police personnel outside their police stations are not wearing masks. The bench of Justice Siddharth Verma and Ajit Kumar observed. In this backdrop, a number of suggestions were put forth before the bench by the appearing advocates. The court has asked the Government Council to consider the same by the next date of hearing. The suggestions are listed as below. All police personnel and all government employees should compulsorily wear masks. Head of every institution in the state of UP should, in the morning hours, every day try to sanitize as many people as possible in their departments for wearing of masks and for maintaining of social distancing. And that's it for Courts Roundup. Stay tuned to APN for more updates.
India Legal presents Courts Roundup.